I can hear you now. I want to inform the court that I tore my left cornea and I'm really having some light sensitivity issues right now due to the abrasion on my eye. So, I'm kind of sitting somewhat in the dark and I'm wearing sunglasses. So
That's
I'll take
that's
them off.
fine.
Okay,
It's
thank
fine.
you.
We just figure you wanted to be incognito for this.
No, not really. Not really. My client was also just trying to find a place to park and she should be arriving in just a moment.
Do you think we can start now with
Well, what are we talking time-wise, Miss Ives?
Probably 2 or 3 minutes.
Okay, I'll give her a few minutes, but then we're gonna start because I don't want to hold
Okay,
else up. And determination of the school. This case was heard over 4 days, which I will state is far longer than any case that I've ever had to hear with these limited issues. There was substantial, irrelevant, and extraneous evidence that was not germane to the issues the court had to decide. The parties did testify about numerous complaints that they had and have against each other, although the court would find that some of these were petty and insignificant. Court notes that if a party was not in litigation, these complaints would probably be innocuous and forgotten by the parties. However, because of the pending case, these complaints are used to bludgeon the other party and cast aspersion on each other. The court has considered all of the testimony. However, I will note that I'm giving greater weight to the most recent events over something that happened years ago. I would state to the parties so they know that credibility is always a consideration in every case. And oftentimes a party will allege that the other party or one of their witnesses is not truthful or is lying. The court has found, however, that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding or misunderstanding, or even mistake. When inconsistencies occur, the court attempts to determine if they can be reconciled by other testimony or evidence. There was some conflicting testimony in this case, but not more than the court would normally expect to see. The court will and has assessed the credibility of the evidence and the witnesses in this case. Pursuant to MCL 722.26A, parties are to be advised of the joint custody, and the court will or shall consider joint custody. To determine whether joint custody is in the best interest of the child, the court should consider the following. Sub A, factors under subsection or section 3, which is the best interest of the child test, and whether the parties will be able to cooperate and generally agree concerning important decisions affecting the welfare of the child. Pursuant to the case of Daly versus Crownhammer at 291 Mishap 660 a 2011 case, the court must consider the general level of cooperation and agreement between the parties when considering joint custody. The question is whether the parties are generally able to cooperate on child rearing matters, not whether the parties necessarily get along. And that's Sherlock versus Richards at 273 Mishap 320, 2006. It appears that both of the parties love Demetrius and have his best interest at heart. They both appear committed to Demetrius' well-being, notwithstanding how they have dealt with each other. Although the parties have been more amiable than the court usually sees in cases. The court will now examine the best interest of the child test as set forth under MCL 722.23. When determining the best interest, as the court has stated, I have to go through, and I'm required by law to go through those particular factors. The first is the love, affection, and other emotional ties existing between the parties involved and the child. Court will note that Lindsay Potter, who was the owner of Bright Light Daycare, testified that Demetrius enjoyed seeing both parents. Dominic Millamrun grew up with plaintiff's older son and lived with him for approximately 6 months. He testified that plaintiff and defendant have a loving relationship. Plaintiff and Demetrius have a loving relationship, and Demetrius snuggles up with plaintiff. He saw love and affection that between them and noted that plaintiff was an amazing father. If Demetrius had nightmares, he would call for both of his parents. Demetrius was happy to see defendant. Defendant and Demetrius showed love and affection, and he believed that defendant and Demetrius were bonded. Zachary Ottinger, who had known the parties for 5 years, testified that plaintiff showed love, affection, that he had hugged when he picked Demetrius, so when he picked him up, that defendant would do the same. Skylar Ward, who is plaintiff's son, testified that plaintiff would guide Demetrius when he had a tantrum. He would talk to him, he would calm him down. He felt that there was bonding between plaintiff and Demetrius and felt that Demetrius loved both of his parents. Alicia Skurlock testified that Demetrius loves the plaintiff, hugs him, that Demetrius climbs all over the plaintiff. And we had a similar testimony that, again, Demetrius has a loving relationship with his mother. I don't find that this factor favors either of the parties, that they both demonstrate this. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation of the education of raising the child in his particular religion or creed. Court will note that this is, again, two things. It's capacity and disposition. The parties could have the capacity, but not the disposition. As stated under factor A, this factor does appear that both parties have exhibited and have the capacity and the disposition to provide Demetrius with love, affection, and guidance. Alicia Skurlock testified that Demetrius tells plaintiff about things that happen at school. They cuddle, and if Demetrius needs help, he goes to the plaintiff to get that. The court had noticed that there also was other testimony from defendant, her witnesses, that Demetrius has the same kind of relationship with her, and it does appear, based upon which I'll get in later when I talk about schooling, that each of them has continued the education of Demetrius in this matter. There's been very little testimony about religion in this case, or any religious involvement, so the court's not considering that. It does appear that this factor weighs equally as to both parties. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized or permitted under the laws of this state in place of medical care and other material needs. Both parties have been provided the material needs for Demetrius when he is in their respective care. Plaintiff testified he does not believe that Demetrius is neglected while in the defendant's care, and defendant testified that she does not believe that Demetrius was abused or neglected while in the plaintiff's care. And both parties have been involved in taking Demetrius to medical appointments, as well as providing for his other material needs. As a result, the court will find that this factor does not favor either party as well. Next is the length of time that Demetrius has lived in a stable, satisfactory environment, the desirability of maintaining continuity. In this matter, it does appear, based upon the testimony of both parties, that they have a stable, satisfactory environment, and there's nothing that was testified to establish that they did not have a stable, satisfactory environment. Court would only note that believe that there was some testimony from the defendant that she might move in the future, but there was none. There was no set date coming up, etc. The court will find that this does not favor either party. Next factor is the permanency as a family unit of existing or proposed custodial homes. Court will note that plaintiff started dating Alicia Sturlock in 2022, moved in together in July of 2022, and it looks like, based upon the testimony, that they get along great. Testimony of the defendant was that she has a boyfriend now for about a year, but again, not residing together. And court will note that neither party testified as any issues in their relationship or any changes as upcoming in either of the homes. So the court will find that this factor does not favor either party. Next factor is the moral fitness of the parties involved. Again,
We just lost.
we lost.
Sir?
We lost.
Yeah.
We lost Ms. Ives.
Permanency of the family unit, that factor.
Okay. Well, as I stated at that point, just to reiterate, that plaintiff started dating Alicia Skurlock in 2022. They moved in together in July of 2022, and it appears that they have a great relationship. Court will note that the defendant testified she has a boyfriend of about a year. And a court will note that neither party testified, whether there was a testimony, that the relationships that they're in were any time volatile or would change in the near future. The court will find that this factor does not favor either party. Next factor is the moral fitness of the parties. There's been no testimony about either of the parties being unfit morally in this matter, so the court will not consider this factor in this case. Next factor is the mental or physical health of the parties involved. In this case, the plaintiff testified that he has no mental or physical health issues. Defendant has not raised any mental or physical health issues involving the plaintiff. Defendant testified that she has depression, anxiety, and has bipolar, and she has been seeing therapists for over a year. In this matter, the question is not what a person's condition is, but does that condition impede their care of the child? Zachary Ottinger testified that he had to pick up the defendant after an accident with a deer. She was emotional, crying, seemed to be dancing around, as he said, her stating ending her life, but she calmed down over the 40-minute drive and exhibited no self-harm during that time, nor had he seen any since that October situation. On October 15, 2022, Demetrius had a soccer game while in plaintiff's care. Demetrius was sick and the weather was not good, so plaintiff kept him at home. The defendant went to the game, and when plaintiff and defendant or Demetrius were not there, she called plaintiff multiple times, but plaintiff did not have his phone with him, and she left a message then that he better answer or he'd get his door kicked in. Plaintiff said that she couldn't reach plaintiff for about 45 minutes. She was anxious and stressed, and she acknowledged that her conduct was wrong and apologized. Another time when she couldn't reach plaintiff, she threatened to come knocking on doors, and the court finds that her actions in response to these incidences were irrational, excessive, and totally inappropriate. It's one thing if, in fact, the child is gone someplace and you have this, if the child is with friends or child's out playing and all of a sudden disappears for that period of time, that would be appropriate. The court doesn't believe it's appropriate when the parent is with a child or when the child is with a parent in any of that. Another incident occurred on 10/17/2022 where defendant told plaintiff to drop Demetrius off at a hotel where she was staying. When plaintiff questioned her as why she was staying at a hotel, she said that it was none of his business. Defendant said she needed Demetrius because she was on the edge. It turns out that now we find that she was in the hotel because her house was being bombed for fleas. It does appear to the court that plaintiff's mental health issues do impede her ability to properly care for Demetrius, and as a result, the court will find that this factor favors the plaintiff. Next factor is the homeschooling community record of the child. Court notes that Bobby Van Werner, she was Demetrius's teacher at Dudley. She testified that both parents came to the open house, both were involved in school, they go to the conferences, and both parents cooperate on issues in this matter. She testified that Demetrius he turns in his homework, he's a smart student in math, reading, and spelling, and she has him working on first grade mental math. She did not testify there were any issues about him missing much schooling, no behavioral problems. He was respectful. The only problem he had was had some issues paying attention. Lindsay Potter, the owner of Bright Light Daycare, testified that the defendant enrolled Demetrius in that daycare. However, both parties were involved, and the only problem was Demetrius had gotten a number of abrasions, bruises that she attributes to her signs, believes that decreased once he had, in fact, received glasses. There was one issue that arose at that time when the plaintiff was removed from the defendant's account. However, that was rectified when plaintiff got his own account. Ms. Warner, who heads the 21st Century program, which is a before and after school program, testified that Demetrius is great at math. He has no discipline issues, no social skill deficiencies, and she has had limited contact with plaintiff, and he was pleasant, but he didn't appear to be interested in the program. The court will find that, again, this factor does not favor either parent in this case. Next factor is the reasonable preference of the child. In this matter, the court did interview the child and will consider that his preference is a factor in this case. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and the other parent. Plaintiff testified that defendant when she does not get her way, she has threatened to keep Demetrius and did so over Christmas of 2022 and early 2023. The court will, however, note that there was no parenting time order in effect during this time. And the testimony shows that both parties have been somewhat flexible when they need to have a change in parenting.
Your Honor, we lost Ms. Ives again.
Okay.
Is having issues apparently. We last heard that the last thing you said that there was no parenting time order after talking about the Christmas break.
Okay. Court will note that based upon the testimony that both of the parties appear to be flexible and allowing time to the other party when something comes up or they need Demetrius with them. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the child. The court will note that the defendant testified that on one occasion, the plaintiff was yelling at her and backed her up against the wall. And she, however, acknowledged that plaintiff never laid a hand on her. Mr. Ottinger testified that he did not see the parties fight. And Skylar Ward, the plaintiff's son, testified that he did not see the parties have any heated interactions and no physical aggression by either party. Although he did on occasion, he said he had heard defendant screaming and throwing things in a room that he was not at. Plaintiff
Did you?
Well,
I was gonna say, did you cut out there, or was there a pause?
No,
I'm sorry,
no,
I
a
thought it was
pause.
my internet.
I think my notes were incorrect. I want to correct those. Defendant's complaints in this matter appear to be her reading too much into what the plaintiff says. as she testified, it was the tone of the plaintiff's communication. And I will state the court addresses facts, not what a party feels about what is said. The issue is what was actually done, not what their reaction was to it, or whether they felt in this matter the tone of it or something of that nature. The court will find that this factor does not favor either of the parties. Any other relevant factors considered by the court doesn't believe that there really was any other relevant factors that stood out to the court. I want to address in this matter the areas where the parties have had disputes and agreements. First, an agreement, the defendant took it upon herself to get glasses for Demetrius. Plaintiff initially didn't think that it was necessary and wanted a second opinion. He took Demetrius to another doctor, and the prescription was ultimately changed. However, the parties didn't argue about it. They didn't fight. They just had a different opinion. And with both of their input, the matter was satisfactorily resolved. Plaintiff changed Demetrius' doctor from Gray's Health to Cereal City Pediatrics because it took too long to get an appointment, and the defendant did not oppose this. Plaintiff also took Demetrius to another dentist, Highland Dentistry, and defendant did not oppose this. The parties did discuss and agree that they would not employ corporal punishment with Demetrius, and plaintiff testified that communication with defendant is sometimes good and sometimes non-existent. Parties had minor disagreement about haircuts for Demetrius, and it ended up with them agreeing or acceding to the fact that plaintiff would take care of the haircuts. Defendant testified that sometimes the communication with plaintiff is rocky, and again, she said she feels again that he's condescending, and then she would get snippy back. Again, the court's not concerned about your feelings, ma'am, concerned about what actually happens. Defendant testified she is willing to make changes to address any issues that they have, and she believed that face-to-face communication was best. Alicia Gerlach also testified that the parties do communicate well in person. Defendant initially enrolled Demetrius in Brightline Daycare, and plaintiff said that he did not have any advance notice, but defendant testified that plaintiff eventually told her to just go ahead. When the parties have to discipline Demetrius and take away his phone or other privileges, they've agreed that they will enforce that punishment while Demetrius is in each of their homes. Defendant enrolled Demetrius in Dudley School because they missed the enrollment in Fremont, and they did not have any agreement as to where he would be enrolled. Plaintiff enrolled Demetrius in Montessori School without consulting plaintiff. Court will note that both parties have taken unilateral action without consulting the other party, but most of the time, the other party has acceded to the actions taken in this particular case. And it appears that both parties have, again, Demetrius's best interest in heart and are able to do what is best for him. Court believes that it is in the best interest of Demetrius that both parties are involved in making decisions for him, and as a result, the court will award the parties joint legal custody. I have found that, except in rare occasions, once a case has concluded, the parties are better able to communicate and make decisions for their child. Now that I have awarded joint legal custody to each of you, I will note and tell you that as you communicate, if you are unable to agree, don't get upset, don't have argument or conflict, simply bring the matter back before the court, and the court will decide the particular issue. Now the court will turn to the issue of schooling. The plaintiff wants Demetrius in the Montessori school. defendant wants Demetrius in the Battle Creek Public Schools, and he has attended kindergarten in Dudley School because she missed the enrollment in Fremont. Demetrius also attends Montessori while in the plaintiff's care. Martha Hosick, who is the secretary of Battle Creek Public Schools, and defendant testified that if Demetrius remains in Battle Creek Public Schools from kindergarten through graduation, he's entitled to take advantage of the Bearcat Advantage, which provides for 100% paid college tuition at any college in Michigan or any NAACP college in the country. David Averill, the principal at the Montessori, testified that the Montessori goes from grade kindergarten to 8th, and that they have no organized sports program, and they have smaller class sizes of approximately 20 students. Plaintiffs testified that he is looking into whether, as a Native American, and he states possibly Cherokee, he would qualify for any programs through the tribe, but nothing has been confirmed, and it's only speculative at this time as to whether he qualifies for enrollment and whether there is any program available. Demetrius appears to be a gifted, intelligent student, excelling in school and advancing in math and reading, which was testified by Ms. Warner and Ms. Van Warmer. And the court believes that there is substantial benefit to the parents and to Demetrius to have guaranteed college tuition, which is paid for in this matter. The court does believe that based upon all of the testimony that Demetrius should continue in the Battle Creek Public Schools. Court will note that it is preferred that he would attend Fremont over Dudley. Court has had many cases involving Fremont School and Dudley School, and court finds that the Fremont School is preferable to Dudley, which is again an underperforming school in the Battle Creek School District. Court will next turn to parenting time. It is presumed in the statute that it is in the best interest of the child to have a strong relationship with both parents. Pursuant to MCL 722.27A1, parenting time shall be granted in accordance with the best interest of the child after examination of various factors, which the court will go through at this time. Factors that the court has to look at is whether there's any special circumstances or needs of the child. The court will find that Demetrius does not have any special circumstances or needs. Next factor is whether the child is under 1. He's not, and so that's not applicable. Next factor is the likelihood of abuse or neglect of a child during parenting time. As stated previously under the other factors, no party has testified that there's a likelihood of abuse or neglect of a child during parenting time. Court will find as well that there's no likelihood of abuse of a parent during the exercise of parenting time. Next factor is the inconvenience or burdensome impact of travel on the child. Parties are within a close proximity to each other, so there's not any excessive travel in this matter. Next factor is whether a parent reasonably expected to exercise ordered parenting time. In this matter, it does appear that both parties have exercised and taken advantage of all their ordered parenting time. And the next factor is whether a parent frequently failed to exercise parenting time. Court will not find that they have either of the parties that failed to exercise parenting time have in fact have wanted more parenting time. Next is threatened or actual detention of the child other than the Christmas 2022. The court notes that there was no threatened detention of the child in this matter, and the court again notes that that occurred when there was no parenting time order in place. Court will note in this matter that the parties are free to and encouraged to be flexible and change parenting time as it may be necessary. However, the court would caution that if there is a change in parenting time, the court would recommend that you put it in writing. And the court will first grant the parties parenting time at all times and places to which the party may mutually agree. And if they can agree, the court will note that the parties have been following the parenting time schedule delineated in the temporary order preserving the status quo entered on October 17, 2023, which provides that the defendant will have Sunday through Tuesday and alternating Wednesdays. Plaintiff will have Thursday through Saturday and alternating Wednesdays. And the party's holiday parenting time was spelled out in the order of November 28, 2023. Both of these schedules have been working satisfactorily, and the court will continue parenting time as continued or provided for in both of these orders. There was some question or confusion as to the start times of parenting time, which was not addressed in these orders. So the court will order that the start time will be 6:00 p.m. The court further ordered that the parties shall, the court further orders that the parties shall receive 1/2 of the summer vacation period in alternating weeks from Friday at 6:00 p.m. through the following Friday at 6:00 p.m. They shall have 1/2 of the Christmas vacation period, with plaintiff to receive the first half during 2024 and each alternating year thereafter, and alternating spring break, with plaintiff receiving spring break 2025 and each alternating year thereafter. The court will not, in this matter, grant a right of first refusal as requested. Court finds that this creates a quagmire, which is fraught with potential conflict and problems, and so the court will not order that in this particular case. Court further order that the plaintiff will continue to receive the after-school periods when Demetrius is in defendant's custody, as provided for in the temporary order when she is working. Court will order that the plaintiff is prohibited from removing from Demetrius from school early. Court needs to address child support. Was testimony by Stephanie Garcia, who is the plaintiff's HR manager, and she testified that plaintiff makes $27.81 per hour for full-time. He does not receive any bonuses. He gets some overtime, but that's only if he's called in, and there's no pattern to that, so the court will not consider that in this matter. Court will note that the plaintiff pays sum of $121.42 per month for insurance, which includes Demetrius, and as a result, the court will order that he is entitled to a deduction for the amount of this insurance premium attributable to Demetrius. The defendant works at Dudes in Coldwater, and she makes $17 an hour. She also works at the Vegas Strip. Oops. We lost.
Sorry, Your Honor, the last thing you said was the defendant works at the Dude.
Okay, she works at Dudes, makes $17 an hour, works at the Vegas Strip Thursdays and Fridays as a DJ, where she makes $10 an hour. And she testified that her yearly income is $17,700. She also testified that she makes between $50 and $60 per weekend in tips. And so the court will average this out at $55 for 52 weeks, which totals $2,860. Adding this year to her yearly income brings her total to $20,560. The court will use those amounts for purposes of calculating the support in this matter. The court will therefore direct Ms. Storm that you would prepare the appropriate judgment in this matter. And the court will direct the attorneys that you can pick up your exhibits if you want within 10 days of today's date, or if you fail to pick them up within that time, the court will have those destroyed. Ms. Storm, is there anything you believe that the court has not addressed or that I need to address before we conclude?
Tax exemptions for the parties for the purpose of child support calculations, Your Honor? Should they be alternating?
The court will alternate those. I don't know if Ms. Storm, can you tell me it did, I'll ask Ms.
My
Ives
clients
as well.
never claimed the
What?
child. My clients never had the opportunity to
Okay.
claim the child.
Okay, as a result, the court will order
Your Honor,
that
my
he get,
client,
go ahead.
oh, my client is okay with alternating the years. She had already claimed Demetrius for 2023.
Okay, the court will order that, the plaintiff is entitled to the tax exemption for 2024 for all tax purposes and each alternating year thereafter. With that, Ms. Storm, anything else that the court has failed to address or needs to address before we conclude?
Nothing is coming to mind, but let me just check with my client. No, there's nothing
Your
further.
Honor,
Thank you.
Okay, Ms. Ives, is there anything you believe that the court has not addressed or needs to address before we conclude?
My client was wondering if the court would make any ruling on the 21st century before and after school program.
That is not a schooling. The court will not order that occurs. So if in fact she wants to have the child in that program, during time she has the child, she can do it, but I'm not going to order that the plaintiff be required to do so.
Your Honor, that interferes with your order that my client be able to take care of Demetrius after school on Monday, Tuesdays, and alternating Wednesdays.
Oh, okay. Well, it does. Well, the intent is that he would have the child when the child is not in her care. So again, if being the fact that the child has to be in that program on the Monday, Tuesday, and alternating Wednesdays, the court would order that, again, he gets that time with the child and that she then would not enroll the child, but she has a right to enroll him in the morning program on those particular days.
Okay, so morning program, okay, but afternoon program is not,
Right.
just so that I'm clear. Okay.
Correct. Anything else, Miss Ives?
I just want to clarify that if my client is out of work when the child gets out of school, she has that time, correct?
That is
It's only
correct.
if she is working, correct?
That is correct, and she will be required to
Okay.
notify the plaintiff if she is not working those particular times, and court will order that she gives him at least 8 hours prior notice. If she doesn't give him 8 hours prior notice, then he still gets to keep Demetrius during that time. You include
there
that
any-
as well, Miss Storm.
I will. Is there any requirement to share schedule?
Well, court would hope that they would do that, but obviously schedules change, so I'm not gonna order it, but it seems like that they would be able to resolve a lot of potential disputes if they exchange schedules, so.
I'll put that language that it's, I'll basically indicate that, but that you're not specifically ordering it, but that it's encouraged.
Okay, thank you. Anything else, Ms. Storm?
I
You
believe
went,
that's it. Thank you.
okay, Ms. Ives, anything else?
No, Your Honor.
Okay, thank
Oh,
you
Your Honor,
all.
one more thing.
Okay, there is, okay.
Your Honor, one more thing. My client in her relief had asked for a weekend that would allow the parties to give makeup parenting time. Is there a way the court would fashion?
No,
At
I'm not,
least,
I know you
some
asked for
order
that.
that
I didn't address that because I was not going to order that. And with the fact that the court has, in fact, now ordered and provided for summer parenting time, she'll be entitled to have a number of weekends in the summer. So I'm not ordering it at this point.
Okay, thank you.
Okay, thank you all. I hope everything works out for you. I think that you've done an excellent job with Demetrius, and you're so far ahead of a lot of other parents in that the issues may seem substantial and insurmountable to you, but quite frankly, based upon what I see, they're very minimal. So I hope everything works out. You're free to go. Have a great day.
Thank you. Have a good day.
Thank you, sir.